processes to make sense of the judgment on the true and proper interpretation of Article 97, 1, G and H in relation to the vacant parliamentary seats controversy. Stay with us here on Ghana Tonight. Still on that issue, we hear some reactions that are already coming in thick and fast to this particular ruling, the reasoning behind it as was released by the... Also, we have a conversation on public health tonight following confirmation of an mpox case in the Greater Accra region, a spike in the number of cholera cases across the country, some 1,600 and over cases of cholera, plus 17 people who have died as a result of this cholera outbreak. As always, you're an integral part of the conversation. Let's hear from you. The hashtag we're using is GhanaTonight on Facebook. And on X, let's get talking. Let's set up the Ghana briefs.
The Supreme Court, in its reasoning for the ruling on the case of vacant seats, has said that the ruling by the Speaker of Parliament, Alban Gbagben, cannot take effect in this current Parliament. In a 109-page ruling, the Apex Court said a Member of Parliament can only be considered to have vacated their seat if they change their political identity and remain in Parliament under the new identity. The flag bearer of the NDC says he is better placed to erect and commission statues in his name than President Akufo-Addo, who has never completed any major infrastructure project. Campaigning in the Western North region, John Mahama says service to the nation must humble any true leader in selfless humility.
Any Ankata Mahabo, Medibaku Besio, Anka Kotuka Airport, Terminal 3, Medibaku Besio, Anka University of Ghana Medical Center, Medibaku Besio, Anka Kwame Nkrumah Interchange, Medibaku Besio, Anka Kaswa Interchange, Medibaku Besio. And so, baby, or this statue, Nuko Sia, and Juma Oya Wahonina, oh ye. Hospital, Homudi Kosi, hospital name, ye, ye. Interchange now, yes, you know, China for no, ye.
Flag bearer of the NPP, Dr. Mahmoud Bawumia, has promised the people of Kwadaso in the Ashanti region of recruiting 5,000 youth from the constituency under the Job and Skills Program. Addressing chiefs, clergy and Muslim clerics, Dr. Mahmoud Bawumia appealed to them to vote for him to enable the vision he has for the youth come into fruition.
Memunuso omohia skills. Yeah, the technical and vocational aba. Omoso omohia digital skills. And we are seeing digital. Uwa digital skills are now ote kwada soha ubetimi aye ejuma ewo America, right from here ewo Canada, ewo Singapore, na ote ha na oju dollars ewo ha wo kwada so right from here. Enti me pese Ghana mbemunu yama omo training in digital skills nebi.
Ghana's 2024 elections promise to be one of the most keenly contested in recent memory, with both the ruling and opposition parties locked in a fierce battle that could very well come down to the wire. Every vote will be crucial in determining the nation's future. However, the issue of rejected ballots looms large as a significant challenge, even threatening the nation's peace during elections.
In spite of the successes we have chalked, right from 1992 to the year 2020, our elections are still characterized by high incidence of rejected ballots. In 1992, we had about 149,000 votes being rejected. In fact, almost all the years, we have them in over hundreds of thousands, which is very, very, very critical for our democracy and for consolidating our democratic process.
As of Wednesday, November 13, 17 districts in 4 regions have so far recorded cases of cholera, with the central region recording the bulk number of cases. Deputy Director of Public Health in charge of disease surveillance at the Ghana Health Service, Dr. Dennis Laye, says 16 persons have so far died from the disease, with 85 on admission.
There have been 16 deaths, unfortunately, and we've had over 1,600 suspected cases. At the last count, we had 17 districts in the 4 regions. Now, that is not to say that these are the only places where cholera may be. If people haven't reported, for example, to be tested, then we may not know.
The Black Stars held their final training session in Luanda, Angola, on Thursday evening. All 23 players trained ahead of the penultimate 2025 AFCON qualifier against Angola on Friday. Utuado and his charges will hope to return to winning ways after losing and drawing to Sudan in the previous international break. Ghana currently sits bottom of Group F, but victory against Angola will send them to third and within 3 points of potentially booking a ticket to Morocco. The match will kick off at 7 p.m. on Friday.
As more news on 3news.com. Make some time and visit 3news.com. This is Ghana Tonight. Coming up next, we go into the minds of the Supreme Court justices to make some sense of their judgment on the true and proper interpretation of Article 97(1) GhanaTonight. That's coming up next here on Ghana Tonight. And also in relation to the vacant parliamentary seats controversy. In fact, this is one that a number of you have been waiting for. The said reasoned ruling of the Justice of the Supreme Court on this particular case. They've brought finality to the true and proper meaning of Article 97 GhanaTonight, that's 1 GhanaTonight, and also the full details of it. We have about 109 pages, which we're going to tease out the major and the standout as it were, areas within this 109-page ruling of the judges of the Supreme Court, explaining the circumstances under which a member of parliament is deemed to have vacated their seats. According to the 5-2 majority decision of the House, an MP can only be considered to have vacated their seat if they change their political identity and remain in parliament under the new identity. You want to understand this? Follow us closely. Dennis Baberi Wadam Esquire is joining me right now. Now, we established, and it's good to have you, those who ruled in favor of the plaintiff and those who ruled against. Yes. Let's establish it from there again. So
5-2, and these are the 5 justices who ruled in favor of the plaintiff. The Chief Justice, the Presiding Justice, Justice Gertrude Tukono, Justice Mariama Owusu, Justice Kwame Esedu, Adibu, Justice Yao Dakwasari, he wrote the majority opinion, and then Justice Yao Jou. So these are the 5 justices who ruled in favor of the plaintiff. Now the 2 who dissented, Justice Amadou Tanku and then Justice Errol Lovelace Johnson.
So and their primary point of dissension was on the matter of jurisdiction.
On matter of jurisdiction, yes.
Fair, perfect.
But let's start with the majority opinion.
Great stuff.
Yes, even though all of them are aligned and they are on the side of the plaintiff, Justice Asiedu had to also write a concurring opinion. What it means is that even though he's on their side, his also has some distinction that meant that it had to be a standalone.
I see.
So, I mean, they dealt extensively with the matter of jurisdiction because when they were filing the memorandum of issues, the AG, as part of the memorandum of issues, set that down for determination. Now, the question was whether or not the case was properly before the Supreme Court, and if the Supreme Court had that jurisdiction to hear the matter.
That's right.
That had come up already. And then the Attorney General was impressing on the 7-member panel to say that, yes, indeed, there was jurisdiction because the 5 had already determined that matter in the applications. So you recall that when the Speaker of Parliament made his application to vacate the ruling of the Supreme Court itself, the matter of jurisdiction came up and they decided.
That's right.
So the Attorney General was simply saying, when the matter of jurisdiction came up again on the substantive matter, that this matter has already been settled on. Let's go on so that it will be taken that you have jurisdiction to hear out. Of course, not all of them agreed. Tanko in particular did not find favor in that particular argument because he thought that jurisdiction as it related to the application was different from as it related to the substantive matter. And he sought to distinguish why they still needed to consider the matter of jurisdiction. But of course, they looked at the issue of jurisdiction. These 5 agreed that indeed they had jurisdiction to hear the matter. These 2 disagreed or they dissented.
Right.
Now, into the other, the substance of the matter itself. I mean, the case as to what exactly Article 97, 1, G and H actually means. That is why it gets interesting. It gets interesting because the justices took their time to break the article down or the provision down just so they could interpret it in a manner that we all can follow.
Right.
But at the end of the day, what essentially stood out and which they took their time to actually tease out was that when you want to appreciate this particular provision, it has to be seen in a certain sense. That one, an MP, for an MP to be deemed to have vacated his or her seat, that MP must have left his party. To leave your party, and that is the party on whose ticket you came into the House.
So, for instance, so Cynthia Morrison
came on a ticket of the MPP. So she must have left the MPP.
As in resigned from the party.
Yes.
Okay. But
so they did not go into that, but per the provision, there is leaving the party and joining another party. So the contention is that, or the argument made is that you must have left the party and then join another party, and then seeking to remain in Parliament on the ticket of the new party that you have joined. So let's say, for instance, you, as an MPP member, you left MPP, I mean, you came to Parliament on the ticket of MPP, you left the MPP, and then you join, say, NDC, and you seek to remain in Parliament on the ticket of the NDC. In that case, you would have been deemed to vacate your seat.
Not that you have the intention of contesting in 2024 as an independent candidate.
So they actually make the point that leaving the party and joining another party has to be seen to be contemporaneous. It means that it has to be now. And the definition of Parliament, as the justices have explained, is within the period of 4 years. So this particular Parliament has a lifespan,
right,
which was from 7 January 2021. It will end on the 6th of January 2025. So within that period of time, if you change your identity in the House and you seek to still be in the House on a new identity, that would not allow you. So that's how come they summarize it in this. And this is in respect of the age, which applies to members who came on the ticket of Parliament, I mean, on the ticket of political parties. That one, so yes, it begins here, that an MP must vacate his seat if he leaves the party under which he was elected to join another party or become independent and seeks to remain in Parliament under new identity. So for them, these are the elements that need to be met for one to be deemed to have vacated a seat if you came to Parliament on the ticket of a political party. In respect of the age, which applies to independent candidates, These are the elements that were formulated by the Supreme Court in aiding us to understand what the provision means. That one, an independent candidate must vacate his seat if he joins a political party in Parliament and seeks to remain in Parliament under his new political status. It does not apply to an intention to contest a future election. After explaining this, they took their time again to explain what the implications of what the Speaker did would mean.
Tell us about it.
They make the argument that it will affect the rights of MPs to have a choice, that MPs, even though they may have come to Parliament on a ticket of a certain party, they still have that right to make a choice as to which party they want to ride on in the next election. So if they make that decision for a next Parliament, that should not be seen to be a vacation of their seat. They also make an interesting point about how parliamentarians have a social contract with their constituents and not with political parties.
I see, but they came into Parliament on a ticket of a political party.
But they were elected by constituents, and they are accountable to the constituents.
I see. So does that mean that the political party then doesn't have a say in whatever the person says?
But they still make a point that it should not be left in the hands of the political party to decide the parliamentary imbalances with internal party decisions.
Does this then negate the provision in the MPP constitution specifically about the forfeiture of the membership? Because if you look at the constitution of the MPP, they state, and we're going to put that constitution of the MPP on the screen in a bit right now, that you automatically forfeit your membership if you, as a sitting MP, decide to either contest on the ticket of another political party or go independent. The automaticity of that constitutional provision kicks in immediately you decide to.
Unfortunately, that did not come out expressly. But when you read in between the lines of what they said about not leaving this decision in the hands of internal party decisions to be made as to altering the composition of Parliament, you begin to appreciate that the Supreme Court wants to take that power of the political parties being able to influence the shape of Parliament. So they make that case of the connection between the member of Parliament and the constituents rather than that connection between the member of Parliament and the party that brought that particular candidate into Parliament. Because
that is the point you make is very important, underscoring this, the reasoning behind this particular part of the ruling, because what we have seen is that, for instance, the parties have an influence in who even becomes a leader of the various caucuses in Parliament, right? And then now you're saying that based on this ruling, the Supreme Court is essentially saying that the political party on which an MP is elected cannot dictate.
They should not be dictated to.
As to whether or not the person is fit to represent the constituents, depending on the person's decision to either go independent or otherwise. But let's look at the MPP constitution, right? And then I'll
and even before, after that, I'll show you something interesting.
Perfect. Now, let's look at this. This is what the MPP constitution says, and let's put it on the screen right now. It says expulsion of a member. A member may be expelled from the party, and it goes on and on. In fact, let's flip to the next one. It says, in the third point, it says forfeiture of membership. A member of the party who stands as an independent candidate against the officially elected member of the party, or who joins or declares his or her support for another political party or for an independent candidate when the party has sponsored a candidate in a general election or by-election, automatically forfeits his or her membership of the party. So this one clearly captures the punishment for an intention. But the Supreme Court says that the intention cannot be punished in the current Parliament. Because if you look at it, look at the notice of poll of all those who have decided to go independent, right? And we have it. This is the notice of poll in the Suhum constituency. The incumbent member of Parliament, Kojo Asante, on the ticket of the MPP, who decided to go independent, is there. This is how the polling, that's the ballot paper, is going to appear. You have Frank Esiedu Bekwin, Protozwa, of the MPP, the sponsored candidate of the party is there. Prince Ado, the NDC candidate, Emmanuel Wiafe, and Kojo Asante, the incumbent NPP MP, is going independent. Let's look at the next one. The next one as well is the case of Cynthia Morrison in the Central Region. This Aguna West. Christopher Atta. The sponsored MPP candidate is there, and Asinofori Dangbe of the NDC, and then Cynthia Mamle Morrison is there as well, as the incumbent MP on the ticket of the MPP and going independent. Let's look at Amenfi Central. Amenfi Central, you have Peter Kwachiaka there as well. So the Supreme Court says...
No, so this is in respect of the next parliament. This has nothing to do with the current parliament. And when you look at what they say are the elements that they formulated, that one, the MP must leave the party under which he was or she was elected. So let's do the analysis. Has any of those MPs left their parties as we speak? Do we know?
Well, the MPP constitution says they will automatically leave if they decide to contest as independent candidates.
That will be a matter for the NDC, the MPP to deal with. In any case, I'll show you, we'll go back into history, and the Supreme Court has helped us to see that there have been instances where members of parliament declare their intention or file nominations to contest as independent candidates, and they were still in parliament. Not one MP, not two MPs, not three, as many as 5 of them.
Perfect.
The Supreme Court took judicial notice of that. Let me show you that real quickly. So here we go. And as far as 1996, there was an independent member of parliament for Kintampo, Gladys Insau. She was re-elected in 1996 on the NDC ticket. She entered parliament as an independent candidate. She did not lose her seat. In 2004, you had Dr. William Akoto, MPP MP for New Ebrim from 2001 to 2004. He retained his seat while running as an independent candidate in the 2004 elections. It doesn't end there. It continues. This is a very popular one. Joe Wise.
Yes.
First entered parliament as an independent candidate for Bekwai. 2009 to 2012. He later contested the election in 2012 to be re-elected on the ticket of the MPP. He didn't lose his seat. The only person who unfortunately lost his seat was the former MP. Now there's a final one. He was also an independent candidate. He contested the primaries while he was an MPP primaries, while he was an independent candidate in parliament. Unfortunately for him, he lost the primary. The argument made then was all these were in respect of future elections, so they could not have been deemed to have vacated their seats.
You know what? Stay the steam on this, and let's bring in Godwin Tamaklo is a private legal practitioner. He is also the director of legal for the NDC. He's been following this case quite closely as well. Counsel, good evening. Thank you for joining us here on Ghana Tonight.
And good evening to your viewers. Can you hear me?
I can hear you. And if you can go back a bit for us so we get the full image of you. Perfect. Thank you very much for joining us here on Ghana Tonight, also live on 3FM 92.7. Essentially, you heard what Dennis has laid out, what the reasoning behind those who ruled in favor of the plaintiff, the Supreme Court justices who ruled in favor of the plaintiffs put out, that the only plausible conclusion which must necessarily flow from a holistic and contextual reading of 97(1) and H is that an MP seat shall be vacated upon departure from the cohort of his elected party in parliament to join another party in parliament while seeking to remain in that parliament as a member of the new party. Counsel.
Okay, so I think it's important that your colleague, he's Dennis, right?
If you could sit back a bit for me, yes, great.
I mean, he's Dennis, is that correct?
Yes, that's right.
Good. So you see, I think he makes a few more matters, he mixes up a few issues that needs to be corrected. So in Ghana, getting into parliament is by 2 ways, either as an independent candidate or sponsored by a political party. Now, when you are sponsored by a political party, you pick the identity of that political party. So you even see that in the notice of poll, it is not just the picture of that individual. You also have the political party and its symbol that is sponsoring the person. When you are an independent candidate, you don't go through that kind of association. Now, it's important, and I like the way you raised the Article 9 of the NPP Constitution. Very instructive. Because you see, what Article 9 of the NPP Constitution says is simple. Now, once the NPP has the officially elected parliamentary candidate, and you take the step of becoming an independent candidate, the party constitution says you forfeit your membership automatically. Now, you see, there's a history to Article 97. And oftentimes, when the Supreme Court has the opportunity to interpret our constitution, the fundamental reasoning is that the constitution is a living organism, but it also mirrors our history. What, therefore, is our history? If you recall, in 1979, the parliament that took its life from 1979 had Victor Usu as the leader of the opposition there against Liman. Now, two principal members of Victor Usu's party, that is Lawyer Kwekuba and J.H. Usua Champon, came on the ticket of Victor Usu's party. They got into parliament, and one day said they were no longer members of Victor Usu's party. However, they said they want to remain in parliament. And in fact, they remained in parliament until the coup of 1981. So when we were drafting the 1992 Constitution, mindful of the events of 1979, we introduced Article 97, 1, G, and H to correct and to cure that 1979 mischief where the person leaves the political party that brought him and still want to remain and do business. So this time round, we introduced the clause vacates your seat, and it's automatic. And so if you look at even the standing orders, Standing Order 18, the Speaker only informed Parliament of the occurrence of that vacancy. Nothing more, nothing else. So we need to understand that as a people, we have walked a journey from 79 till now. And so that what happened in 79, we do not want it to repeat itself. And so you notice that the Supreme Court, with the greatest respect, in seeking to interpret Articles 97, 1, G, and H, had no recourse to our history and why, for the 1992 Constitution, we introduced those specific provisions. Two, the Constitution contemplates two things happening, and that is reference to Article 112. In Article 112, 5, and 6, it said that if the events in Article 97 happens 6 months before the next election, then you can have a by-election. However, if it is just 3 months to the next election, then there's no opportunity for by-election. So the issue that people will be denied representation does not even arise. The framers of the Constitution cured it. Now, to the judgment itself, Alfred.
Okay.
You would notice, reading from page 4, the heading is Facts. The lead author of the majority judgment, His Lordship Justice Yao Asare Daku, in recounting the facts that originated this whole action, admitted that at the time when Afenyomakin Honorable issued the writ out of the registry of the Supreme Court, Speaker has not taken any action. Now, if that is the case, then as at the day Afenyomakin issued the writ, he was only seeking an opinion from the Supreme Court. That is without. Please go ahead.
That is if the writ was not amended, as it were.
And exactly.
We don't have records of that, but that is if it wasn't amended.
And you see, Afenyomakin and his lawyers after Speaker informed the House of that decision, didn't go back to the court to amend their pleadings to reflect these new facts, these new events.
If they had done that, would we have known, or?
No, it's a matter of record. In fact, the judge himself concedes. And one thing that you must understand, that the Supreme Court, with the greatest respect, doesn't operate like an octopus. You see, the octopus has many tentacles. So it goes everywhere looking for something to justify something. In this specific case, it's a court of record. The matters before the Supreme Court, as at the time it was giving judgment, were the pleadings, the writs, and the statement of case. The statement of case recounts the factual basis that is informing the invocation of the jurisdiction. Now remember that this is not an appeal. This is an original action pursuant to Article 2. Now what you need to ask yourself is, what is in Article 2? Article 2 says that if I come to the court alleging that Alfred had acted or had failed to act, so we use an act or omission, which contravenes an express provision of the Constitution, I can come to the court and invokes its original jurisdiction. Now, question is, on Monday, when Afenyo-Markin issued the writ out of the registry of the Supreme Court, has Speaker taken any decision? No. So where did the Supreme Court get those facts from?
Okay,
and that is why, if you look at the minority opinion, His Lordship Justice Amadou Tanko recognized that defect. He recognized the defect in that particular process, and in fact made this very important pronouncement. If you permit me, may I just read what he said?
Briefly.
Alfred, can I proceed?
Quickly, yes.
He said, the court is not a court to elicit opinions or academic information, but settles life disputes. Therefore, where a contention brought before the court, especially if the same is anchored on the invocation of the court's original jurisdiction, is not life, it is fanciful or frivolous.
Okay.
It is a waste of judicial economy for the court to entertain same. Further, the court must not be seen to be hiding under its interpretative function to be making laws as if it were Parliament. So you see, His Lordship Justice Amadou Tanko realized quickly that the plaintiff here, Afenyo-Markin, never came back to the court to amend the writ and the statement of case to now plead those new facts, which is the conduct of the Speaker. And you see, that is why you notice that whereas the Supreme Court granted relief 1, the majority granted relief 1, they couldn't go further in making any further consequential orders.
But, well, Counsel, but I mean, you saw Dennis make reference to the precedents. In fact, 5 instances that the Supreme Court justices who ruled in favor of the plaintiff referenced. And out of those 5 instances, only one who suffered the consequence of losing his seat in the case of the former MP. And so, really, why should that be the only reference point for the justification of this action by the Speaker?
No, but you see, that's it. You see, as far as the judgment is concerned, this point raised is immaterial.
Why is that?
No, because you see, when you go back to the reliefs which were attached to the rates, it simply creates an issue of futuristic, or everything that is done is to the future. And that, for instance, if you move from independent to MPP, okay, that movement from independent to MPP, right, does not take effect now, except the election that you are going to contest.
Okay.
Meanwhile, Alfred, if you pick your constitution, Article 97, you see by Article 97 the word tenure of members. That tenure, obviously, is just an aid to interpretation. That tenure is not futuristic. It is a now. 2, as we speak, the MPP, then MPP MP for Agona West, Cynthia Morrison, having taken the positive step of filing formally before the Electoral Commission her candidature to be independent, by reason of Article 9(3) of the MPP Constitution, she is no longer an MPP member. So, with respect, you see a certain level of confusion in the judgment of the Supreme Court majority. Because what it means is that you can wake up in the morning as an MPP member. By close of day in the evening, you are no longer an MPP member. But by reasoning of the Supreme Court, you can still remain in Parliament.
Well,
how is that even possible when it is the party that sponsored you? Because you see, this decision of the Supreme Court takes us back to 1970.
So the Supreme Court puts supremacy on the constituents represented by the MP, and not necessarily the party who sponsored him having to dictate the status of the person in Parliament.
Let me tell you, if you are Fred, assuming you go to Keita, listen carefully, or Ketu South, and you say you are an MPP member, that alone can decide your future. If you go to Bantama, and you say you are an MPP parliamentary candidate, or you say you are an NDC parliamentary candidate, that alone will decide your future. So to suggest even remotely that political party associations have no bearing, with the greatest respect, is to completely lose the game. Because, like I pointed out earlier, Article 97, 1, H, and G were specifically put in there to cure a problem. Now, Supreme Court has taken us back to 1979. So what it means is that by the reasoning of the majority Supreme Court judges, what it means is that you can actually leave your political party for whatever reason and still remain there. Or your party can say, so and so person is no longer our member.
I tell you what, this is
but
just...
then you can still remain in Parliament for God knows.
Okay.
And that is where, and let me make another quick point.
In 30 seconds, I need to round up on this quickly.
Yes, in 30 seconds. You also note that the Speaker never filed his defense and statement of case, more or less, right? However, the majority judges appears to take the view that the Speaker raised an issue about their jurisdiction. Where from that?
Okay.
Where did they get that view from?
Well, Counsel, this is the beginning of a number of days ahead of us that we're going to interrogate and have conversations on various parts of this 109-page ruling. But I do appreciate your time for this initial part of the conversation. Thank you. Thank you so much for joining us.
I appreciate the opportunity.
GhanaTonight Tamaklo is private legal practitioner, also the director of legal for the NDC. Dennis, now there's a quick point you want to make there. Very quick one.
Well, it just had to do with the Supreme Court's position that
absolutely
the attempt to take the power away from the political parties in determining the balance in Parliament. And I quote what the Supreme Court says precisely, that Article 97(1)G does not give political parties the power to disrupt the balance of Parliament by removing MPs based on internal party decisions. And that was precisely what the Supreme Court said in that particular respect. And the filing processes that Council talks about, it describes those as mere administrative processes that are required for every election. So yes, those were addressed, all right, but what was essentially said was the fact that they do not want to leave that power in the hands of political parties to disrupt the balance of parliament.
Okay, perfect. Now, this is a conversation that, look, we're going to stay this theme on in the coming days in our subsequent bulletins here on TV3 and across all media journal platforms. And stay with us here on Ghana Tonight, also on your Election Command Center. Coming up next, Dennis Poberi Wadam Esquire is here with me. We have a conversation on public health tonight, following the confirmation of an mpox case in the Greater Accra region and a spike in the number of cholera cases across the country. And this is one that we've been keeping an eye on quite closely, and the concerns that have been raised as well on this particular issue. One more mpox case has been recorded in the Greater Accra region, bringing the total number of cases in recent weeks to 3. The Deputy Director of Public Health in charge of disease surveillance at the Ghana Health Service, Dr. Dennis Lai, tells TV3 the identified contacts are currently being monitored. Take a look. We're going to go for this quick break. When we're back, our guest will join us and we'll have a conversation on this particular issue. And then also we're keeping an eye on how things are playing out at the Electoral Commission distribution points for the ballot papers, parliamentary ballot papers. Stay with us. We're back shortly.
A home is never complete without the warmth of family, the assurance of security.
cases in recent weeks to 3. The Deputy Director of Public Health in charge of disease surveillance at the Ghana Health Service, Dr. Dennis Lai, has been speaking to us on this. Take a look.
We had the outbreak in Western North. I think it's been contained. There was one case confirmed in the Greater Accra region. The region has done their investigations. So far, we haven't identified any new case, even amongst the contacts, but we're still following them up to determine if anybody develops symptoms. The case was confirmed last week. It's actually mild. The person is quite very well, and so that has been handled. But as I said, sometimes when you get these cases, you want to be double sure that there aren't others out there that we haven't picked. And so the region is working with the district concerned to make sure that they've been able to follow up all the contacts.
Let's have it further. Professor Richmond Aite, a public health expert, is joining us from Geneva right now. Thank you, Prof, for time here on Ghana Tonight. Now, this latest case confirmed in the Greater Accra region of Mpox. Looking at the demographics, the makeup of the Greater Accra region, busy, hustle and bustle, and considering the fact that this Mpox is transferable from one human to another, what should be the containment measures put in place?
Well, for this particular kind of disease, the spread is from person to person and also from animal to people. There are two main ways to deal with it. Person to person is that if you suspect somebody has the symptoms, and essentially it's fever and related conditions, headache, etc. And the way Ghanaians we usually do when somebody has those conditions, then what we do is try to do self-medication. We should avoid that. It helps protect us, but it also helps protect the next person. So if you suspect you have any condition, especially when such a finding has been made, the first thing you should do is seek health care, because you may not know. And at the very beginning, when somebody has the virus, you would not know what it is, and it will not show physical signs like the characteristic effects that it shows on the skin may not show until a few days after. And therefore, it is important to seek care and be careful about coming into contact with those people. And this is physical contact, and sometimes even just being in the environment where they are. Now, that's what individuals, me and you, we can do. There is the aspect of the public health services being heightened across the country, where our health workers would then do contact tracing. I would want to assume that that is, by the way, if you look across the continent, we are not the only ones facing this challenge. We just need to do what it takes to protect our population so that it doesn't begin to spread wildly. On our part, what we can do are those that I have mentioned. Make sure that we are exercising appropriate hygiene as well. You know, we learned a very good habit during the COVID taught us to wash our hands frequently, and also be careful about shaking everybody's hands. We've gone back and we are just throwing all that caution away. I think that we should all be our brother's keeper and start protecting ourselves as best as we can and exercise those hygiene practices. It would help us, even in the absence of this mpox. It can also help us prevent other diseases. Now, what I'm seeing also is that we are having cholera also breaking out. I mean, come on, in this day and age, a country like Ghana, shouldn't be having that kind of challenge. But again, it boils down to hygiene, environmental cleanliness. In this day and age, we still have people who are defecating out in places where they are not supposed to.
True.
Perhaps we are also facing the challenges of a difficult economic situation because people may be finding ways to ration water. And if you are rationing water, then you cut corners in terms of how you wash your hands, how you keep cleanliness, and all those things have to be part of the broader
approach to dealing with this, Prof. And I do thank you, and you couldn't have diagnosed us any better than this, and the recommendations as well. The point that you make there spot on about the cholera outbreak, and as we saw there, the statistics we put on the screen in terms of cholera has hit 17 districts, 1,600 suspected cases, 16 people have died so far as a result of the cholera outbreak, 85 on admission as we speak. And certainly, as you put it, that should not be associated in this day and age of Ghana. But here we are, and we're dealing with it. Professor Richmond Aite is a professor of public health, nutrition at the University of Ghana School of Public Health, joining us from Geneva. Appreciate your time. Thank you for joining us here on Ghana Tonight. But before we go, we're picking information that some individuals have invaded the Patahon town area within the Nyong South Forest Reserve in Takwa and Siam Municipal Assembly in the Western region. Now, information available suggests that they are protected powerfully. Some built men, the well-built men with 4 escape vehicles on standby. The pictures you see there, for the benefit of those listening to us on radio, you have excavators busily destroying the forest with the other earth-moving equipments as well, turning the forest cover upside down. And that is what we got from one of our viewers just some few minutes ago in the said location. We're keeping an eye on this one. Stay with us here on Ghana Tonight. Trust that we're getting to it. On behalf of the rest of the team, I want to say thank you so much for staying with us. Join the New Day team tomorrow morning on the Sunrise on 3FM 92.7 team as well tomorrow morning. I'm Alfred Okonse. Have a good night.
Ghana Tonight is brought to you by
Flamingo Paint. Superior durability, superior hiding, superior coverage, simply superior.